Okay, hello class, and today we have another lecture covering chapter 3 of the book. We will cover article 128 until um, 142. So that covers chapter 3, dissolution and winding up. Again, article 1828 to 1842. So 1828 defines what is dissolution. So dissolution is a change in the relation of the partners caused by any partner ceasing to be associated in carrying on of the business of the partnership. So dissolution, that is the point in time where the partner ceases to carry the partnership business together. So there are three final stages of partnership. We have number one, dissolution, where the partner ceases to carry business together. Second, we have winding up. Winding up is the process of settling business affairs after the dissolution, or what we commonly know as liquidation. And the last part is termination. This is the point wherein all the partnership affairs are already wound up. No, nahuman na ang liquidation, or the business affairs of the partnership are already settled, then maupama terminate ang partnership. Okay. So, that is 1828, the definition of dissolution. Now, in Article 1829, it states there that dissolution of the partnership dissolution of the partnership is not terminated but continues until the winding up of the partnership affairs is completed. So again, dissolution is only the first stage, termination is the last stage, the third stage. Now, when the partners decide to dissolve the partnership, it does not automatically terminate the partnership. Again, naay three process. We have dissolution, and then the partnership needs to settle the business affairs, that is what we call winding up, before the partnership is totally terminated. Now, what are the causes of dissolution? That is what is provided under Article 1830. So there are two kinds of dissolution: the extrajudicial dissolution and the judicial dissolution. So when you say extrajudicial dissolution, this is without the intervention of the court. So Article 1830, paragraph 1 to 7, that is extrajudicial dissolution, while paragraph 8 talks about judicial dissolution. So when you say it is a judicial dissolution, there is intervention of the court. Okay. So what are the grounds? What are the grounds or causes where the partners would extrajudicially dissolve a partnership? So without violation of the agreement between partners. There are four cases wherein the partners may dissolve the partnership without violating their agreement. Number one, by termination of the definite term or particular undertaking specified in the agreement. So earlier, in the first chapter, we said that there are many kinds of partnership. We have a partnership with a fixed term and a partnership for a particular undertaking. Now, if the term arrives or the particular undertaking is finished, then the partnership may decide to dissolve the partnership. That is the first ground for dissolution. Second is by express will of any partner who must act in good faith when no definite term or particular undertaking is specified. This is in cases of partnership at will. So again, we go back to the principle of delectus personae. The right of the person to choose his partner. So when the partners already decided that they do not want to be associated with each other, then by their will and in good faith, they may terminate or they may dissolve the partnership. So they may dissolve by their will or by their decision. Third case is by express will of the partners who have not assigned their interest or suffered them to be charged for their separate debts either before or after the termination of any specific term or particular undertaking. So basically, paragraph 1C still needs to have good faith. Now, the partner who wishes to dissociate or dissolve the partnership must do it in good faith. So that is why uh, it states there that partners who have not assigned their interest or suffered them to be charged for their separate debts. No? So meaning, partner nga way utang. Kaya kung usa ka partner nga daghang debts and would want to dissolve the partnership, it would seem that it is done in bad faith. And then paragraph 1D, by expulsion of any partner from the business bona fide in accordance with such power conferred by the agreement between the partners. So when one of the partners is expelled from the partnership in good faith, so again, when we say bona fide, that is in good faith, and it is in accordance with the rules laid down in the Articles of Partnership, then the partnership may be dissolved. So those are the grounds for dissolution that is without violating the agreement between the partners. However, a partnership may also be dissolved in contravention of the agreement between partners where the circumstances do not permit a dissolution under any other provision of this article by express will of any partner at any time. So it means dili siya masud sa paragraph 1 because the partner would like to dissolve the partnership in bad faith. They may also do that when they have agreed to dissolve the partnership. Okay, third paragraph. Okay, or Article 1830, number 3, by any event which makes it unlawful for the business of the partnership to be carried on or for the member to carry it on in partnership. So when the business of the partnership becomes illegal, then it basically follows that the partnership must be dissolved. Or when one of the partners can no longer be a partner, for example, he has been removed by court. His rights have been removed by court, for example, then the partnership may be dissolved. Number 4, when a specific thing which a partner had promised to contribute to the partnership perishes before the delivery, in any case by loss of the thing, when the partner who contributed it, having reserved the ownership thereof, has only transferred to the partnership the use or enjoyment of the same, but the partnership shall not be dissolved by the loss of a thing when it occurs after the partnership has acquired ownership thereof. So what does this mean? So for example, the partner promised to deliver, when we say specific thing, it is irreplaceable, no? So when a partner promises to deliver a specific thing, however the property perishes before delivery, then the partnership may be dissolved because there is lack of contribution from the partnership, from the partners, and diba, when we talk about partnership, it's about contribution of the partners to the partnership, to the common fund. And however, if the thing perished and the after the delivery of the said property to the partnership will not be dissolved. So, ma-dissolve ang partnership if nawa ang property before delivery. However, if the property is lost after the delivery to the partnership, it does not dissolve the partnership. And then number 5, by the death of a partner. So when one of the partners die, then the partnership is dissolved. Number 6, by insolvency of any partner or of the partnership. So when you say insolvency, usahay in layman's term, we use the term bankrupt. No, so when you say insolvency, the liabilities are greater than the assets. Mas daghang utang kaysa sa mga properties nga ikabayad. So if a partner or the partnership becomes insolvent, they may dissolve the partnership. And then number 7, by civil interdiction of any partner. So what is civil interdiction? It is a penalty imposed by the court wherein a person is deprived to exercise his property rights. In most cases, civil interdiction is given to convicts who are imprisoned for more than 6 years. So if ang judgment is usually, for example, lifetime, mo-follow ana nga na ay civil interdiction mo sa ka-person, he can no longer exercise his property rights, then the partnership may be dissolved. But civil interdiction only comes with a final conviction or judgment. So if dili pa sige ongoing pa ang kaso or nanay judgment or nanay decision on civil interdiction, however, the accused partner is still appealing, then it is not yet final. So when the judgment becomes final and it is adjudged that the said partner shall suffer civil interdiction, then the partnership may be dissolved. Okay. So that is in case those are the grounds wherein the partners may dissolve the partnership extrajudicially. And number 8, by the decree of the court under the following article. So again, judicial dissolution is a kind of dissolution wherein there is intervention of the court. Now, what are the grounds for judicial dissolution? So under 1831, on application by or for a partner, the court shall decree a dissolution. So dapat na ay partner nga mo apply. So what are the grounds for judicial dissolution that is provided under 1831? So number 1, when a partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. However, there is a presumption of sanity. So kung gusto ka nga ma-dissolve ang inyong partnership because you think that your partner is already insane, then you have to prove in court that indeed that partner is insane and or that partner is of unsound mind. Second ground for judicial dissolution, when the partner becomes in any other way incapable of performing his part of the partnership contract. So incapacity of the partner. So again, you have to prove it in court that your partner is indeed incapacitated, thus there is a need to dissolve the partnership. Number 4, a partner has been guilty of such conduct as tends to affect prejudicially the carrying on of the business. So for example, the main business of the partnership is to provide loans. Small loans to other people, and then one of the partner is guilty of estafa. So who would trust a partnership wherein one of the partners is convicted of estafa, fraud, or pangilad? So they may dissolve the partnership on such ground. Number 4, when a partner willfully or persistently commits a breach of the partnership agreement. Okay, so if there is an intentional breach of agreement by one of the partners, then any of the partner may go to court and ask for a judicial dissolution. Or number five, when the business of the partnership can only be carried on at a loss. When the partnership business is already losing and the partners believe that they could no longer save it despite adding additional capital, then they may file a judicial dissolution of the partnership. And then number six, other circumstances which renders a dissolution equitable. So number six is a catch-all phrase, no? So kung wala kailaing grounds, pwede na ka number six. Because you file a dissolution because that is what justice requires or something like that. No, for any other reason when you want to file a judicial dissolution. Okay. And then, okay, so those are the grounds for 1831. So let's go to 1832. Except as so far as may be necessary to wind up partnership affairs or to complete transactions begun but not then finished, the solution terminates all authority of any other partner to act for the partnership. So what does this mean? When the partnership is dissolved, any of the partners cannot bind the partnership anymore. So when there is already extrajudicial dissolution, even if the partnership remains because they still have to wind up the business affairs, all acts of the partners can no longer bind the partnership except those provided in the preceding article, that is in 1833 and 1834. So, okay. So what is 1833? Where the dissolution is caused by the act, death, or insolvency of a partner, each partner is liable to his co-partner for his share of any liability created by any partner acting for the partnership as if the partnership has not been dissolved. So if ang dissolution is caused by an act, death, or insolvency of a partner, the partners are still liable to the partnership as if it has not been dissolved unless the So general rule, if ang dissolution is because of a death or insolvency of a partner, the partners are still liable. Except, number one, when the dissolution being by act of any partner, the partner acting for the partnership had knowledge of the dissolution. So kahibaw, katong partner nga aning file nga dissolve ang partnership, he has knowledge of the dissolution. And then number two, dissolution being by the death or insolvency of a partner, the partner acting for the partnership had knowledge or notice of the death or insolvency. Because sa death or insolvency, diba, this is an extrajudicial ground for dissolution. So if the acting partner had no knowledge of the death or insolvency, they are still liable as partners. However, if naanay knowledge sa death or insolvency, then the acts of the partners do not or will no longer bind the partnership. Okay. 1834, again, that is an exception to the general rule, which states that when a partnership is dissolved, any of the partners cannot bind the partnership, except in Article 1844. So, what are the instances wherein the partnership is liable despite dissolution? Number one, when the act is appropriate for winding up partnership affairs. So, kung reason nga nung ni act ang usa ka partner is for liquidation purposes, then that is allowed. Number 2, when the act is for completing transactions at finish at dissolution. So kung na pa yung mga transactions and then na-dissolve na ang partnership, kinahanglang tiwason ang transactions and it binds the partnership. Number 3, any transaction which would bind the partnership if dissolution had not taken place, provided the other party to the transaction had extended credit to the partnership prior to the dissolution and had no notice or knowledge of the dissolution. So, kung nagpautang, the creditor still has the right to ask for payment of the debt. No? Or, even though he had not extended credit, but nevertheless known of the partnership prior to dissolution, having no knowledge or notice of the dissolution, the fact of dissolution had not been advertised in a newspaper of general circulation in the place of which the partnership was regularly carried on. So for example, so number 3, if ang transaction is to a creditor, even if naanay dissolution, kinahanglan gihapon mobayad ang partnership to the creditor or any other transaction other than credit, but ang katong third person nga ning transact with the partnership had no knowledge of the dissolution because the fact of dissolution was not advertised in a newspaper of general circulation. So in those cases, the partnership is still liable despite being dissolved. So what are the instances where the partnership is not liable? So where the partnership was dissolved because it was unlawful to carry on the business. No? Because the business has become illegal. So basically, dili na liable ang partnership except when the act again is for winding up partnership affairs. Or where the partner has become insolvent. Kung wala ikabayad ang partner, so dili na liable ang partnership. Or where the partner had no authority to wind up partnership affair. So, usually, in winding up, naara na yung mga specific na mga partners assigned to do the winding up. So, if the partner had no authority to do the winding up, then the partnership is not bound. Except by a transaction with a third person who is in good faith. So, always, if na ay good faith, mabound jud ang partnership. Okay, so instances wherein the partnership is bound and not bound at the stage of dissolution of the partnership. So let's go to Article 1835. So 1835 states that the general rule, the dissolution of the partnership does not itself discharge the existing liability of any of the partner. So, when the partnership is dissolved, it doesn't mean that the liability of the partner is also dissolved. However, in order for the liability to be discharged, the following must agree. So, the partners themselves, the partner, the other partners, and the creditors para ma-discharge the partner from his liability. So, again, the dissolution of the partnership does not dissolve the partner of his liability. However, the partner, the individual property of the deceased partner shall be liable for all the obligations of the partnership incurred while he was a partner, but subject to the prior payments of his separate debts. Now, because for example, the cause of the dissolution is the death of a partner, diba? 1835 states that the partner is still liable despite the dissolution. So, unsa na may ibayad sa usa ka dead nga partner, then all the remaining properties of the dead partner shall be charged with the liability of the deceased partner. So, that is 1835. Article 1836 talks about the kinds of winding up. So when there are two kinds of when there are two kinds of dissolution, there are also two kinds of winding up. So we have extrajudicial winding up, wherein the liquidation is done without the intervention of the court. So kinsa may mo wind up, kinsa may mo liquidate. So there is what we call the liquidating partners. So the liquidating partners, they only enter the partnership when the partnership is already winding up its affairs. However, the partners may also agree to designate liquidating partners. Or partners who have not wrongfully dissolved the partnership, diba? There was a ground in dissolution wherein it was done in contravention of the agreement of the partnership. So kung kinsa tong who did not wrongfully dissolve the partnership, he may be in charge to liquidate the business assets, or the legal representative of the last surviving partner who is not insolvent. What do we say last surviving partner? So for example, tulo ka partners, and then nagdugan sila og kamatay atong tuiga. So kinsay pinaka-last ang legal representative sa pinaka-last nga namatay nga partner maoy mo liquidate sa partnership affairs. So that is in extrajudicial winding up. Now in judicial winding up, again, there is intervention of the court, and who will wind up the partnership affairs, any person who is appointed by the court. So that is 1836. Let's go to 1837. No, if you try to look at 1837, you will be overwhelmed because it's too wordy. No, it's too wordy. So let's discuss 1837 by paragraph. Okay. So when dissolution is caused in any way, except in contravention of the partnership agreement, each partner, as against his co-partners and all persons claiming through them in respect of their interest in the partnership, unless otherwise agree, may have the partnership property applied to discharge its liabilities, and the surplus applied to cash the net amount owing to the respective partners. Okay, so let's go back to the grounds of dissolving the partnership. So when the ground in dissolving the partnership is without contravention or violation of the partnership property, number one, the partnership property will be applied to discharge the liabilities of the partnership. So this is how you apply, no? So winding up na, this is how you apply the partnership property. Pero mayroong bayaran sa partnership property is ang liability sa partnership. Number two, if there is surplus, kung naay sobra after sa pagbayad sa mga liability sa partnership, then it is applied to pay in cash the net amount owing to the respective partners. So, kung pila ang share sa kada partner, kung naay surplus, mao pa ihatag ang mga share sa partner. If the dissolution of the partnership is in contravention or violation of the partnership agreement, how do you wind up the remaining assets? So number one, the rights of partners who has not caused the dissolution wrongfully, katong mga partners in good faith. So number one, again, ang partnership property applied always to the liabilities of the partnership. If there is surplus, then ito nga sa partnership according to their share of the capital. And then, to be indemnified for damages caused by the partner who caused the dissolution wrongfully. So, katong mga innocent partners, they can ask for damages against those partners in bad faith. And lastly, they can continue the business in the same name, either by themselves or jointly with others, during the agreed term of the partnership and for that purpose may possess the partnership property. So for example, usa na ka partner in bad faith ning dissolve sa partnership. Ang katong mga partners in good faith or innocent partners, they may continue the business of the partnership. Now, what are the rights of a partner who wrongfully caused the dissolution? So, if the business is not continued by the partners, again, partnership property is applied to the liabilities. If there is surplus, he can receive his share of the surplus less damages. Okay, diba? We said in the first, a while ago, that the partner in good faith must be indemnified for damages. So, asa man kuhaon ng damages dito sa surplus nga cash for the partner in bad faith. So, minus damages na ang ijang madawat. Or if the business is continued by other partners, the value of his interest in property, so for example, 10% ra ang isang interest sa property. So, kung pila ang surplus, 10% ana, less damages again. No, there is always less damages because he is a partner in bad faith. He needs to pay for damages. But then, he is released from all existing liabilities of the partnership and he is considered no longer a partner. Okay. 1838. What are the rights of a partner who is entitled to rescind? Okay. So, when we say rescind, mo i-end ang partnership, no? When a partnership contract is rescinded on the ground of fraud or misrepresentation of one of the parties thereto, the party entitled to rescind, so these are the rights, no? For example, ang partnership, ang usa ka partner, he was defrauded by one of the partners and because of that, he wants to dissolve the partnership. So, unsa may right ani nga partner nga giilad? So, number one, he has the right of lien or right of retention. Meaning, he can retain the surplus of the partnership property after satisfying the partnership liability. No? So, pwede maidya ang katong sobra sa ipangbayad sa partnership liability. And right to subrogation, meaning to stand in place of the creditors of the partnership for any payments made by him in respect of the partnership liability. So, kung napay suktunon ang partnership, pwede si partner in good faith ang manukot ato. That is the right of subrogation. And lastly, the right of indemnification, which is the right to be indemnified with damages against the person guilty of fraud. So again, right of retention sa surplus, the right of subrogation or the right to collect the other credits of the partnership and the right to be indemnified of damages. 1839 is the rules on settling the account. So, how do you settle the partnership property? Kinsa may una bayaran, kinsa may last bayaran. So, that is laid down under 1839. Okay. So, it states there, what are the assets of the partnership property? What are the assets of the partnership? So, it states there, number one, the partnership property, meaning the properties that are acquired by the partnership during its existence. And number two, the contributions of the partner necessary for the payment of all liabilities. So, diba, we said in the first place, partners need to contribute to form a common fund. So, the contribution is part of the partnership property. Okay. So, those are the assets. What about the liabilities? What about the liabilities or ang mga bayro nun sa partnership? So, number one, pinaka-priority ang partnership creditors, mga nautangan sa partnerships. Second, ang mga partners. Primero, ang mga owing to the partners, meaning mga creditors who are also partners. And the third are those owing to the partners in respect of capital. And those owing to the partners in respect of profit. So again, ang order of preference sa liability, primerong bayaran ang mga creditor sa partnership. Kung napay sobra, bayaran pod ang mga creditor nga partner, meaning ang partnership nakautang ani nga mga creditors. Kung napadyoy sobra, ibalik ang kapital sa mga partners. And if naapagadyoy sobra pa jud, then ang kita na or ang profit. So, pwede ma-return ang capital and ang profit. Pwede po ang capital na ma-return or worse, ang utang na ang ma-return. Or worst, what joy ma-return. So, again, partnership is a business and business is a risk. So, that those are the risks in entering into partnership. So, in 1839, the partnership, when the partnership assets are already exhausted, and then na-apply ko ang mga liabilities or bayro nun ang partnership, the partner shall contribute the amount necessary to satisfy the liabilities. So, kung napadyoy kuwang ang partnership properties to pay for the liabilities, then kinahanglan mo shell out or mo contribute ang mga individual partners. So, who can enforce the additional contribution? The assignee for the benefit of the creditor or any person appointed by the court shall have the right to enforce the contribution. So, pwede mo file ito sa court. Or number 2, any partner or legal representative shall have the right to implement the said enforced contribution to the extent of the amount to which he has paid in excess of his share of the liability. So, for example, si Janing Tapal, ang katong partner nga ning Tapal, pwede sila maka-enforce nga mo add og additional contribution. Again, if the reason for the dissolution is because of the death of the partner, the properties of the deceased partner at to i-charge ang mga bayro noon. So, okay. How about when a partner becomes insolvent or his estate is insolvent? For example, ang katong deceased partner insolvent siya at the same time. So, unhon sa ugbayad ang utang atong deceased partner, and then bago pa ang partnership creditor. So, in case na sa death or insolvency sa usa ka partner. And then, partners by way of contribution. So, again, what is important in 1839 is you have to remember the preference in cases in payment of the liability, no? The order of payment. So, number 1, partnership creditors. Number 2, creditors who are also partners. Number 3, capital. No, the capital of the partners. And number 4, the profit of the partners. So, that is what you need to remember in Article 1839. Okay, so we're almost done. Let's go to Article 1840. So basically, it's quite a long. It's a long article. It's overwhelming, but basically it states there that when the business of a dissolved partnership is continued, then the creditors of the old partnership becomes the creditors of the new partnership. So, muna na pasabot anang 1840. And when a new partner is admitted to that existing partnership, if there are liabilities under the old partnership, he shall not that the new partner shall not be personally liable, but only the partnership property will be liable. And also in 1840, it also states there that in cases where the partnership is continued and the property of the deceased partner shall not be liable for the debts of the creditors of the old partnership. So basically, 1840 just states that if magpadadyon ang partnership despite acts of dissolution, then ang old creditors will become creditors of the new partnership. And then 1841, these are the rights of the partners who retire. So when we say retire, gusto na mohawa sa partnership, or dies and the business is continued without settlement of accounts, meaning there is a dissolution but there is no winding up. No, there was no settlement of affairs because they do not want to terminate the business. They just want to continue it. So sa may rights sa partners nga gusto na mohawa or rights sa rights sa namatay. So number 1, to have the value of his interest at the date of dissolution ascertained. So pwede dyan mangutana pila naman ang ahong interest ani nga partnership. And second, to receive as an ordinary creditor an amount equal to the value of his interest in the dissolved partnership with interest, or at his option or the option of his legal representative in lieu of interest, the profits attributable to the use of his right in the property of the dissolved partnership. Meaning, pwede, mahimo na siya usa ka creditor. No, mahimo na siya usa ka creditor and maka-receive na sila sa ilang share as mura na siya gibayran sa partnership. Kay gusto pa man mo continue ang partnership at sila gusto naman sila mohawa. So, bayran na naman sila sa isang share and ang interest would be profits. No? As kay ang creditor naman dyan na interest because he is not generally a creditor. Kung pilay profits accrued to his share, he will also get it. So that is 1841. And then, lastly, we have 1842, the right to an account of his interest. So, who has the right to an account of the interest of a partner? So, any partner has the right to account of his interest or his legal representative. So, who has the obligation to render an account? We have the winding up partners or the liquidating partner or katong surviving partner when in cases of the last surviving heir and the person or partnership continuing the business. So when is the proper time to render an account? At the date of the dissolution. So once mahibaw-an na nga ma-dissolve ang partnership, partner may now demand for an accounting of his interest. And once there is accounting of interest and payment of all the liabilities of the partner, we enter to the last stage of the partnership, which is termination. So, dissolution, winding up, and termination. So that ends chapter 3, dissolution and winding up, covering where does this start again? Covering Article 1828 until Article 1842. Thank you and click the subscribe channel. Sige.